Let's talk about how Milagro Gramz got ate up by the judge in the Megan Thee Stallion defamation lawsuit. If you don't know what I'm talking about, Megan Thee Stallion has sued a YouTuber for basically making some defamatory marks about her regarding the whole Tory Lane scenario. And Megan Thee Stallion is kind of accusing this Milagro Grams lady. I've never watched any of her videos, but accusing her of actually being like the little mouthpiece for Tory Lane. So the things that she is being accused of saying about Megan Thee Stallion is absolutely insane. And the judge is not feeling it. And I'm going to tell y'all right now, if I was this girl's attorney, I would be very much so recommending that she figure out how to settle this case because the judge is not on her side. Is absolutely not on her side at this point. We are going to go ahead and jump into an order responding to Milagro's motion to dismiss this case. Now, we're not going to go over the motion to dismiss and Megan Thee Stallion's response and then Milagro's reply. We're not going to get into all of that, but we are going to just talk about the order because it does go through everything that each one of them alleged, how the court balanced those things that each one of them alleged, and how they are deciding against her. And y'all, let me tell you, the stuff she is saying is absolutely insane. So let me go ahead and jump right into it. Let's have Bossy B bring us in. Like I said, let's talk about it. Let's talk about Megan Thee Stallion having to come out here and sue a YouTuber. If y'all recall, recently there was another rapper that had to come out and sue a YouTuber. Yeah, that's the Cardi B versus Tasha K lawsuit, in which Tasha K came out and said, yeah, I said it and I knew I was lying, right? So she has to pay Cardi B, and apparently they worked out something to where there is a payment plan that Tasha K is on. I'm really surprised that Tasha K's channel is still going. This Milagro girl, I don't think she's going to cancel her channel because she's going to need her channel in order to pay off this debt that she's about to owe Megan Thee Stallion. Now, like I said, Tasha K said, yeah, I said it. I knew I was lying, but I knew I would get more views if I say the thing. This Milagro girl goes, yeah, I said it, but it's opinion. It's opinion is what she's going to go with. So let's jump right into it and see what this lady or what the court has to say about what we have going on right now. So let me just share the screen with y'all. Here we go. So this cause came before the court upon defendant Milagro Elizabeth Cooper's motion to dismiss the first amended complaint filed on December 23rd, 2024. Plaintiff Megan Pete filed a response to which defendant filed a reply. The court has carefully considered the record, the parties' written submissions, and the applicable law. For the following reasons, the motion is granted in part and denied in part. The little bit of this that the court denies, it's a little bit, okay? It's a little bit, and we're going to get into it in just a moment. So let's see what background the court found relevant for this case. This case centers on allegations brought by plaintiff, a Grammy award-winning artist. Why did I say it like that? Artist, known professionally as Megan Thee Stallion, against defendant, an online personality who goes by Milagro Gramz or Mob's World. Plaintiff accuses defendant of engaging in a coordinated campaign to smear and harass her through social media using video, audio, and written posts to cause reputational harm, emotional distress. The allegations are connected to the fallout from the 2022 conviction of Daystar Peterson, popularly known as Tory Lanez, a Canadian rapper and singer who was found guilty of assaulting plaintiff with a firearm following a widely publicized trial. The court is going to give that a lot of weight because, like I said, the things that this girl is accusing Megan Thee Stallion of is stuff that was said on the record under oath. So under penalty of perjury, if it turns out that she did actually lie, Megan Thee Stallion could be in trouble criminally. But this girl is out here probably very unlikely to be able to prove that Megan Thee Stallion lied on the stand because of the views that she needed to get on her YouTube channel. One thing I noticed about her YouTube channel, she doesn't really show her face either. It was very hard for me to get a picture. That's why our thumbnail is very blurry right now, okay? Because it's very hard to get a picture of this girl. Anyways, Daystar, also known as Tory Lanez, he Actually, the court has actually approved for him to be deposed. So I'm very interested to see what he is going to have to say under oath in this case. And Milagro, who is allegedly, by what Megan Thee Stallion saying, Tory Lane's mouthpiece, right? She didn't really object to him being deposed. So we're gonna get to hear what Daystar Tory Lanez has to say behind. Is his name Tory Lanez? Why do I keep calling him? Yeah, it is Tory Lanez. I was like, Daystar just sounds so off. That threw me off. But Tory Lanez, see what he has to say under oath and see what he thinks about Megan Thee Stallion's testimony. That is going to be really interesting to me. I don't know what y'all thinking, but I think it's going to be really interesting. So, defendant operates multiple social media accounts across platforms like Instagram, TikTok, X.com, and YouTube, collectively amassing over 100,000 followers. Now, she's not as big as Tasha K. Tasha K had 1 million followers just on YouTube. So 100,000, sis, I'm telling you, you might want to settle before this gets too big. This gets too big for you, girl. A plaintiff asserts that defendant has sole control over these accounts and allegedly under Peterson's direction uses them to harass and defame plaintiff by disseminating false narratives and conspiracy theories. These include claims that plaintiff lied under oath, suffers from alcoholism, and is mentally retarded and needs a guardian. Now, trigger warning, y'all, for anyone that has any sensitivity to addiction, alcoholism is talked about this. And we are also, they're using the R word, calling her mentally impaired. Okay. We're going to use that for this live stream. And I'm trying to catch it, but it's everywhere. Okay. So these alleged falsehoods have severely impacted plaintiff's mental health, leading her to contemplate unaliving of herself. The Peterson trial. Fully understanding defendant's defamatory statements requires context from the Peterson's trial and conviction. That's very important. Tory Lanez was convicted for the things that he allegedly did against Megan Thee Stallion. And this girl is getting on the internet and telling us that Megan Thee Stallion lied. Girl, bad move. So on July 12, 2020, Los Angeles police conducted a traffic stop involving Peterson and plaintiff following reports of gunfire in the area. During the stop, officers discovered a recently discharged firearm with an empty magazine and observed that plaintiff had sustained injuries to her feet, later confirmed as gunshot wounds. Peterson was arrested for possession of a concealed weapon while plaintiff was transported to the hospital for treatment. About a month later, plaintiff publicly identified Peterson as the shooter via social media, leading to his eventual indictment on charges of felony assault with a firearm, illegal possession of a firearm, and negligent discharge of a firearm. During Peterson's trial, plaintiff testified for the prosecution, recounting the night she was shot and the trauma it caused her in her personal and professional life. She recalled stepping out of his car, at which point he raised the gun, shouted, "Dance." Yeah, we got to cuss today, and fired 5 shots, injuring her feet. The plaintiff also revealed that the incident and her decision to testify sparked backlash from parts of the music industry and online supporters of Peterson during the trial's media coverage. And it did. A lot of people was against Megan Thee Stallion and said that she was lying. A lot of people were on the internet saying she was lying, but this girl apparently went really, really hard. I didn't watch any of her videos. Maybe I need to go back and watch them, but I don't know. It seems a bit messy. But maybe she needs some views so that she can pay what she's going to owe Megan Thee Stallion, because I'm telling you, the way that this judge eats her up, we can even tell about how deep she's going into this trial just in the background. We're only in the background of this lawsuit. And the judge is like, this is what happened. This is what happened. This is what happened. Okay. So let's go on. 10 days after plaintiff's testimony, Peterson was convicted on all charges and sentenced to a 10-year prison term. The harassment campaign. Defendant allegedly attended the entire trial. During and after the proceedings, defendant purportedly on Peterson's payroll and acting at his direction, launched a smear and harassment campaign against plaintiff on social media. This campaign included the use of bot accounts to flood plaintiff and her supporters with hateful, derogatory, and malicious statements. On one occasion, defendant even called for violence against plaintiff. The overarching goal per plaintiff was to maliciously injure The overarching goal per plaintiff was to maliciously injure her reputation and inflict severe emotional distress upon her. Plaintiff asserts this effort was for retaliation for her testimony against Peterson. In executing her smear campaign, defendant allegedly made several defamatory statements, which plaintiff categorizes into three main accusations. Plaintiff lied under oath during Peterson's trial. She is an alcoholic and she is mentally impaired. We're going to use impaired, not the R word, y'all. And in need of a guardian. Plaintiff asserts that these statements were made with actual malice, as evidence disproving them was widely available at the time they were published. Let's remember, Megan Thee Stallion is a celebrity. She is going to have to prove actual malice versus negligence as to whether it was true or not. And actual malice is either she knew or she made the statements with a reckless disregard, whether it was true or false. So let's go on. There is a deep fake video, which is basically like an altered video via AI to make it look like somebody's doing something that they're not actually doing. So let's talk about the deep fake video. Defendant allegedly took her harassment a step further by promoting a deep fake spicy content, we'll call it, video depicting plaintiff. Defendant in her Mob's World X account liked a post featuring the video and then directed her followers across social media and anyone who saw the post to browse her then public likes page. She directed anybody who follows her public like page, right? Plaintiff insists that this was done to amplify the video's reach. Now, I looked at her Twitter, but not for the reason of seeing the deepfake video, y'all. She has like 100-something followers on Twitter. And so she doesn't have a big following on Twitter. She has a decent following on YouTube. I'm assuming her other followings on Instagram. I didn't get to look at that yet. And she only has like 100-and-something followers. And then she is leading the 100-and-something followers plus anyone that finds out about the link that she liked to this video of Megan Thee Stallion engaged in spicy content, but it's an AI video. It's not real. Neither one of them asserts that the video is real, okay? Next, we go on to the plaintiff's claims, which is Megan Thee Stallion. On December 10th, 2024, plaintiff filed her amended complaint alleging defamation per se. Count 1, promotion of altered spicy content under the Florida statute, intentional infliction of emotional distress. Count 3, and cyberstalking under the Florida statute, which is count 4. In response, the defendant brings this present motion seeking dismissal of the amended complaint in full for failure to state claims for relief. Of course, we know that we are reviewing failure to state a claim under the legal standard. You have to plead facts sufficient enough to basically show that if they have the evidence, they would be able to prove it. The court views the facts most favorable to the plaintiff. So it's very hard to get a case dismissed at the motion to dismiss stage, okay? Unless, like in Diddy Jay-Z case, the person agrees to just go ahead and dismiss it. There's other reasons why you can, but in this situation where it's defamation and it's going to be a question of fact, the court is very, very unlikely to dismiss it. And although that is normal for the court to be very unlikely to dismiss it, the court did not have to eat this girl up the way they ate her up, okay? They did not have to do such things to this lady. Well, honestly, this lady didn't have to do such things to Megan Thee Stallion. So, I mean, I guess you reap what you sow. So let's talk about the discussion. Defendant raises 5 grounds for dismissal. Why does this defendant want to dismiss these claims? First, defendant contends that plaintiff failed to provide her the required pre-suit notice for her defamation claim. Second, defendant argues her statements are not actionable, and even if they were, plaintiff has not alleged actual malice as required she do for public figures. Third, defendant claims plaintiff has not adequately alleged the defendant promoted the deepfake video. Fourth, defendant asserts that plaintiff's allegations are not sufficiently outrageous to sustain an IIED claim. Fifth, defendant insists that plaintiff has not complied with the statutory prerequisites for her cyberstalking claim. Defendant also asked the court to strike some of plaintiff's requests for attorney's fees. Plaintiff opposes each and every defendant's argument. The court considers the arguments in turn. So first, we're going to talk about the pre-suit notice. So this plaintiff is suing Megan Thee Stallion for defamation, right? What this plaintiff is going to say is that Megan Thee Stallion needed to send her a letter warning her that she was going to file a defamation lawsuit so that she would have the opportunity to take it down. The court goes ahead and says that this is the rule that she's citing under this Florida statute. Before any civil legal action is brought for publication or broadcast in a newspaper, periodical, or other medium of libel or slander, keep that in mind, y'all. Newspaper, periodical, or other medium, which can be video, but it's clearly referring to news sources, right? Of libel or slander, the plaintiff shall, at least 5 days before instituting such action, serve notice in writing on the defendant specifying the article or broadcast and the statement therein which he or she alleges to be false or defamatory. The Florida Supreme Court has explained that one of the objectives of this statute was to afford newspapers and periodicals an opportunity to make a full retraction to correct errors and avoid exposure to punitive damages. Unsurprisingly, then, every Florida court that has considered the question has concluded that the pre-suit notice requirement applies only to media defendants, not private individuals. So this girl, Milagro Gramz, thinks she is the newspaper. She thinks that she is a media source because she has a YouTube channel. Okay. And I think on YouTube, she has somewhere above 50,000 subscribers. But yeah, she thinks that she is the media, right? Okay, let's see. The parties dispute whether defendant qualifies as a media defendant. Based on plaintiff's well-pleaded allegations, the court concludes she does not. So this is the first thing that the court is in favor of Megan Thee Stallion. We're going to hear this a lot throughout this document. So the court does not think that she is a media defendant. To determine whether a party qualifies as a media defendant, courts assess whether the defendant's function is to inform and initiate an uninhibited, robust, and widespread debate on public issues. Simply put, the media defendants are those who engage in dissemination of news and information through the news and broadcast media. Some Florida courts have applied this exception to so-called blogs, which are a modern function equivalent to the traditional news. So she's basically trying to say she's kind of like a blog and that Megan should have given her notice. Defendant styles herself as a blogger who reports on various pop culture items, not just plaintiff. Plaintiff's allegations, however, which the court must accept as true, paint a different picture. Plaintiff claims defendant is a longtime mouthpiece for Peterson. Defendant engages in a concerted effort to harass and discredit plaintiff on his behalf. Nothing about this alleged conduct suggests an effort to impartially disseminate information. They cite a case where the court declined to find a public relation firm was a media defendant because it did not issue unsolicited, disinterested, and neutral commentary. Remember, the only thing that this girl is allegedly saying about Megan Thee Stallion is bad stuff. She's only saying bad things about Megan Thee Stallion according to the lawsuit that's being filed. According to plaintiff, defendant has even publicly admitted that she is not a journalist. So not only is she saying bad things about Megan Thee Stallion, she's trying to say that she is a media defendant, and while also simultaneously admitting online that she's not a journalist, i.e. she's not a media source. Okay, she's just giving commentary. She's just giving her opinion. I don't have to give both sides of the story. Kind of like my channel. I don't have to give both sides of the story. I do try to be objective, but some stuff is just stupid and I have a position on it. Okay. So, Megan Thee Stallion is saying she is not a media source and the court is agreeing with Megan Thee Stallion. The allegations thus depict a campaign, not journalism, and the court cannot find that defendant is a media defendant entitled to protection under that section. So she loses on phase one of her trying to get the motion dismissed. Let's go ahead and talk about defamation per se. And count one, and the defamation per se, we are going to talk about what she actually says about Megan Thee Stallion that made Megan Thee Stallion want to file this lawsuit. So the defamatory remarks that are not true that Megan Thee Stallion is saying is hurting her reputation. We're about to get into that right now. So in count one, plaintiff alleges defendant defamed her through three distinct assertions: that she lied under oath during Peterson's trial, and that she is mentally incompetent and requires a guardian, and that she is an alcoholic. The statements as alleged by plaintiff are reproduced below. So these are the exact statements that this lady said about Megan Thee Stallion. At the end of the day, we gonna have some cuss words today. Y'all gotta read along to see what I'm cussing about, okay? At the end of the day, lying on somebody is down low. Yes, she got hurt and that's cool. It's cool, girl. Okay. But how did you get hurt? How? And what are the circumstances? And what after that? So you think I'm finna be sitting up here boo-hooing for a that played up in y'all face? Not mine, because I always said her was lying. I don't. You think I feel sorry for the I don't. The a with a I'ma slap the hoe. I can say hoe on YouTube, can I? And whatever comes after it comes after it. So that was a rant. Okay. That was a rant. And I would tell y'all, I clicked on a video. Of hers. To kind of see what her videos kind of seem like. And she posted something, I believe, when did I read this? I think I read this on Monday. On Monday, I think she had just posted something. Her video was just straight ranting about any and everything. That's the topic of her stream. It's ranting. So all these cuss words do not surprise me. Kimmy went ahead and gave me information. Oh, I guess I clicked on the wrong follower account because Kimmy is correcting me and saying that I think you found the wrong Twitter. Yes, I think I found the wrong Twitter. She has 30,000 followers on Twitter. So scratch that, what I said. I guess I clicked on the wrong thing. And then for Instagram, she has 43,600 on Instagram and 75,300 on YouTube. So I was wrong about all the numbers. So yeah, don't quote me. That's why you got to watch the whole video for context, because I was wrong. And I'm okay with that. Thank you, Kimmy, for finding that for us. So that was the first defamatory thing that Megan Thee Stallion is claiming that she said about her. And that has to do with the perjury accusations from the Daystar Peterson trial, i.e. the or otherwise known as the Tory Lanez trial. So next thing that is perjury related is that she says, this is Milagro Gramz is saying about Megan Thee Stallion, all this case taught anyone was that your father, brother, cousin, or son could face 20 years in prison without proper evidence. This botched investigation and another likely suspect because non-credible witnesses said you did something and y'all is cheering. Okay. Next thing she said, he shot her because his ego was bruised. She's the bigger star. That's never been a fact and sure ain't one today. Peterson is behind bars, presumed guilty, getting better numbers and charting. Wait, so you said he shot her because so you admit that he shot her? So what is she lying about? Or was she being sarcastic? I don't know. Next thing that she says regarding perjury is, I believe that this is exactly how they feel about you, plaintiff. I believe that this is exactly how they feel about you. We know you a lying hoe, and you have absolutely ruined Peterson's life. He ruined his own life by shooting people. And you know what? Other thing about Daystar, he wasn't even supposed to be having possessions of guns. That was one of the big issues. I believe he had like some type of felony or something to where he could not possess firearms. And that was one of the main things he was convicted of, if not the main thing. I don't even think he was convicted of the shooting. I could be, don't quote me, I could be wrong. But my understanding, my remembrance on this is that he was convicted of being in possession of a firearm when he was not supposed to be. Okay. I know he was charged with assault, but I don't know if he actually got convicted for that. Next thing she's saying related to perjury. Was Megan Thee Stallion caught trying to deceive the courts again, basically accusing her of lying? Next, we go into accusation of the mental incompetence. Remember, she's saying that she's mental, she lacks a mental capacity and she needs a guardian. She needs someone to basically make decisions on her behalf. So let me go find this receipt of Megan's ex-bestie telling me that she was a T. Ferris, that's her guardian, that she was not having spicy intimacy with T. Ferris because that's her guardian. Next thing Megan Thee Stallion is alleging this girl said about her is okay, back in 2020, I'm doing what I do now, and rumor was circulating that plaintiff was T. Ferris, I reported on it, and since old girl and his friend/family watched my show, one of her besties and I had an internet rapport with. Well, no, let me start over. I reported on it, and since old girl and her friend/family watched my show, one of her besties that I had an internet rapport with hit me. As you can see, she said it wasn't possible for plaintiff to be sleeping with T. Ferris because he was her guardian, like a father figure. I thought the verbiage was odd, but as time went on, I realized that plaintiff is slow and needed one, so it made all the sense then. So she's calling her slow, and she needs help making decisions, apparently. Another thing that she said about her having a lack of mental capacity is, what is plaintiff's mental status? Does she have a guardian or not? Has she been listed as a capable person? Has she ever been deemed like legally R-worded? Not R-worded, like gray, mentally incapacitated, I'm going to go with. Like anything of that nature, anything of that sort. I mean, she's asking questions, but she's wanting you to infer that, you know, she's not mentally competent. So you're presuming that she lacks mental capacity, right? Next thing, the accusations regarding alcoholism. You ought to be somewhere for your alleged crimes, drunkie. Why do you even speak? Like, does your liver even function well? Next thing, when you have drinking seemingly running through your family, yes, I did post certain questions to my page. Yes, I did. So she's admitting to saying the stuff. Plaintiff comes from a family of alcoholics because the fact of the matter is you have a grandfather that was an alcoholic. Your daddy was your daddy on drugs? Question mark. Or was he in and out of the system? What was that for? Do you want to talk about that? Is stealing worse than drugs? And yeah, so we got a lot of cussing. And then, okay, can we pull up the conviction so we can talk about that a little bit later? I want to get through this because it's a lot. So those are the statements that Megan Thee Stallion is suing under defamation. So saying that she's an alcoholic and her family, if she said called her whole family alcoholics too at this point. She also is saying that she is mentally incapable and she requires a guardian, which is a pretty serious accusation. And then she's also saying that she lied on the stand, perjury, which again is also a pretty serious accusation because she can get in trouble criminally for that. And you can't just say that kind of stuff about people. So let's go ahead and get a little bit deeper into it. To state defamation under the Florida law, a plaintiff who is a public figure must allege publication, falsity, actual malice, actual damage, and the statement was defamatory. Defendant asserts that this claim fails because the alleged statements amount to opinion or hyperbole, and plaintiff does not adequately plead actual malice. So what is opinion and hyperbole? Let's talk about first how you can get defamation, right? You have to say a fact. A fact is something that can be proven true or false. An opinion cannot. It's just what someone's thoughts are. And so what the defendant is saying is that she cannot be guilty of defamation because these are just her thoughts and her opinions. But you're questioning whether she's mentally stable. And it's like, oh, did you overcome that? Oh, are you still a liar in court? Like, I don't know if these are opinions. I don't know if these are opinions. You're saying that she lied in court. That can be proven true or false. The jury clearly found her testimony credible. So is it true or false? I don't know. Let's see. A hyperbole under Florida law, a defamation claim requires that the statement at issue reasonably capable of a defamatory interpretation. What am I saying? Under Florida law, a defamation claim requires that the statement at issue be reasonably capable of defamatory interpretation. This determination is to be made by the trial judge in the first instance prior to the jury's evaluation. A court should assess the relevant statement through the lens of how a reasonable person might interpret it, taking into account the circumstances in which it was expressed. An opinion is capable of being true or false, and therefore cannot be an opinion is incapable of being true or false, and therefore cannot be defamatory. But when an opinion implies undisclosed defamatory facts as its basis, it may still be actionable. Like an opinion, hyperbole is not actionable as statements that cannot reasonably be interpreted as stating actual facts about an individual cannot be defamatory. And so what the court is basically saying is, like, if you are basing your opinion on something that you are considering to be a fact, that can still be actionable. So her saying, is she lying on the stand again? Because I thought she was lying before, or someone said she was lying before. That's what I thought. But did she actually lie in the courts, right? Saying, have she been proven to be mentally capable to make decisions on her own? That's inferring that you do not think that she is mentally capable of making decisions on her own. That is something that can be proven true or false. Does she actually have a guardianship case open, or a conservatorship? Well, depending on what state she's in, which is Megan Thee Stallion lives in California, so it would be a conservatorship. Does someone have a conservatorship over her where they're making decisions for her? That can be proven true or false. You're saying a specific person is her guardian / conservator. That can be proven true or false. And you're saying, is she free, right? Is she able to make decisions on her own? Those things can be proven true or false. And she's basing her questions on things that she wants you to basically say, oh, no one ever came out and said she doesn't have a conservatorship, so she must have one. So there's that. Let's go ahead and jump into the perjury part of things in the analysis that the court has. Defendant characterized her statements in the perjury category as mere assessments of plaintiff's credibility as a witness in the Peterson trial, and argues that even if these statements amounted to an accusation of perjury, they remain non-actionable as opinion and at worst a hyperbole. She maintains that such criticism and disagreement with the jury's verdict is natural, and that her statements framed as calling plaintiff not credible rather than a liar fall within that discourse. They go ahead and cite something that says juries and trials observers will form their own opinions regarding the credibility of witnesses, documentary, and physical evidence. Some observers may give credence to some witnesses and not to others. Alternatively, defendant claims that her statements were substantially true and thus not defamatory. Plaintiff insists that defendant's statements were false, factual assertions, while emphasizing the courts have consistently treated perjury accusations as verifiable statements, because perjury is a verifiable statement. But my girl said all in one breath, and the court points this out, she said all in one breath that the statement is an opinion, so it's not defamatory. And then she goes, well, it is a fact, but it's substantially true. So which one is it? Is it an opinion or is it a fact? Opinion or fact? Opinion or fact? You can't do both. I get the alternative arguments, but you had to admit in your alternative argument that it was a fact. You could say, if the court finds that this is a fact rather than an opinion, alternatively, I argue this. But to come out and say, oh, this is a fact and it's substantially true, your attorney didn't write that argument very, very well. You have to say, if, however, the court finds that I'm wrong and it is a fact that can be proven true or false, you have to write that if. You can't say this and that. You have to say this, and if this, then that. That's it, very specific, okay? Very specific. Going on. Plaintiff's allegations taken as true indicate the defendant was not merely opining on the jury's verdict or plaintiff's credibility. She accused plaintiff of perjury, calling her a lying hoe who ruined Peterson's life, and questioning whether she was caught trying to deceive the courts again. Given the context of Peterson's trial, a reasonable person could view these statements as factual assertions about plaintiff's testimony rather than mere opinion. They cite a case that held that accusations of perjury are sufficiently factual to be susceptible to being proven true or false. You can give your opinion, but you have to use that clarifying language to let people know that you are giving an opinion. They cite another case that says whether a publication is defamatory becomes an issue of fact for the jury, where the publication is susceptible of two reasonable interpretations, one of which is defamatory. This is particularly true here, where defendant made no effort to couch her statements as expressions of opinion, omitting even minimal hedge language like I think, or what's the other one? I believe, or I think, or classically indicative of opinion. She didn't say any of that. She just said she on the stand lying again, y'all. She didn't say, I think she's on the stand lying again. And the court says, you got to use some language to kind of calm it down. Let us know that it's an opinion. You're basically making assertions that she lied on the stand, which again can be proven true or false because it can subject Megan Thee Stallion to a criminal trial. Okay? It has to be able to be proven true or false. Perjury is a crime. Nor can defendant's statement be dismissed as mere hyperbole. Why can I not say that? Hyperbole. I've been saying that like all week. Because accusing someone of lying in court is not exaggerated rhetoric. It is an assertion of fact that can be disproven. They cite a case noting that true hyperbole, I think I'm saying it right, but it sounds wrong to me, cannot reasonably be interpreted as stating actual facts about an individual. At minimum, a reasonable person can interpret defendant's statements as factual claims about plaintiff, and in this context, there is simply nothing hyperbolic about the allegation of perjury. They cite another case that says this writing is not the sort of loose figurative or hyperbolic language which would negate the impression that the writer was seriously maintaining that the petitioner committed the crime of perjury. Not only is she not putting that qualifying language to make it an opinion, like I think, my thoughts, my opinion, my belief. She's not putting any of that. She's saying it multiple times. You want to turn around and say it's an opinion, but you're going around saying it multiple times. And I have not seen any articles, any cases, anything coming forward that's saying that Megan Thee Stallion lied. And not only is there nothing coming forward saying that Megan Thee Stallion is lying on the stand, there was evidence to support her claim that Daystar shot her, and he was found guilty and sent to jail. And you're still saying she lied on the stand? The jury clearly gave her some type of credibility, but you on YouTube saying she doesn't have credibility, that's just your opinion? Well, say, I think she lied. I think the jury got it wrong. You can say that. I think the jury got it wrong. You can say that. We say that all the time on this channel. We can say, I think the judge got it wrong. You can say that. That's an opinion. Not she on the stand lying again. That's not an opinion. Okay. Defendant also attempts to recast her statements as substantially true by attaching live stream transcripts and X.com posts to her motion, offering alternative, potentially non-defamatory interpretations. Again, how she thinks it should be viewed, similar to what we just saw with Diddy on Tuesday. But these materials are not properly before the court, while the incorporation by reference doctrine allows the court to consider documents attached to a motion to dismiss. That exception applies only if the document is referred to in the complaint, not the response, right? Not in just the motion to dismiss. Central to the plaintiff's claim and undisputed, meaning its authenticity is not challenged. And so Megan can't challenge the authenticity. She filed it attached to a motion to dismiss. So there's some problems there. While plaintiff mentions certain X.com posts and live streams in her amended complaint, she does not reference the specific portions defendant now seeks to introduce, nor does the court find that these materials are central to plaintiff's claim in the way that defendant suggests. In any event, plaintiff disputes the authenticity of the transcripts, and understandably so, because they were generated by artificial intelligence and supported by an unsworn declaration, which ends the court's inquiry As for the X.com post, defendant provides no accompanying records and ultimately offers nothing for the court to verify their content or authenticity. They cite a case declining to take judicial notice of a Google Map image as it would have required authentication under the Federal Rule of Evidence 901. They basically would have had to check the internet and make sure that's exactly what it said. She turned it into the court and said, "These are my Twitter posts," but she did not put, "These are my Twitter posts. I swear, under penalty of perjury, that these are true and accurate copies of my Twitter posts." She just basically gave it to the court and was like, "These are my Twitter posts." In other words, if they were not really her Twitter posts and she didn't put it under penalty of perjury, she could not be convicted of perjury because she didn't put it under penalty of perjury. Like she's claiming Megan Thee Stallion is perjurious. Okay. So here we go. Even if considered, these materials do not establish that defendant's statements were substantially true. The substantial truth doctrine does not demand perfect accuracy, only that the gist or the sting of the statement be true. Before reaching that analysis, however, the threshold question is whether the statements are capable of a defamatory meaning, and an issue of law for the court to decide. The court gonna decide against you, girl. They are going to decide against you. At most, defendant's explanation introduced ambiguity, precisely what precludes dismissal. If a statement is revealed to be confusing and ambiguous, raising the question of whether listeners might have heard it in a defamatory way, a jury question is presented, so the court cannot dismiss it. They cite another document saying a certain defendant's statement that plaintiff just does not tell the truth stems from a past relationship between Peterson and plaintiff. For example, defendant contends that the question, was plaintiff caught trying to deceive the courts again, is not defamatory when viewed in full context. The full statement reads, was plaintiff caught trying to deceive the courts again? The answer is yes if you ask her former cameraman, Emilio Garcia. After Garcia filed a lawsuit alleging an unstable work environment, Megan Thee Stallion filed to dismiss the lawsuit brought against her with the potential to have the case refiled in New York. The thing is, Garcia is calling BS and says plaintiff is lying and lives in California. He has hotel receipts, text, I'm assuming she meant to put, and emails. But context does not eliminate the ambiguity inherent in the initial question. Is yes affirming the let me go back. But context does not eliminate the ambiguity inherent to the initial question. Is yes affirming that Garcia believes a plaintiff was trying to deceive the courts for the second time? If so, defendant's question could imply that plaintiff previously deceived the courts when she testified at the Peterson trial. Or yes, merely a statement of Garcia's opinion, which defendant is relaying. The ambiguity matters. So you can't dismiss it. It's going to be a question for the jury to try to figure out. If a statement is susceptible to both defamatory and non-defamatory interpretation, the court cannot resolve the issue as a matter of law. Defendant's explanation does not erase the potential defamatory meaning of her words, and thus the court cannot deem them non-actionable. So the court itself cannot dismiss it. This is going to be a question for the jury. Okay. And again, the court is not really fully considering her attached rest of the tweets because it's not before the court technically, but they still went a little bit further so that it's harder for her to go up on appeal by saying, oh, well, they didn't consider, what the tweets actually say. I can attach a declaration later. They went that step further and they analyzed it both ways. One, we can't consider your additional tweets, but for the sake of argument, we're going to consider the tweets to let you know you're still wrong. We'll still rule against you even if you do appeal it and bring it back to me at a later time. Make sure y'all are leaving y'all comments of what y'all think about this case. And don't forget to hit the like button. I don't know. I didn't make a like goal for the stream. We're at 17 likes with 24 people watching live. I think we can hit 25. So if you haven't hit the like button, please do. It does help us out in the stream. Let's go ahead and jump on to the court's opinion regarding defamation about the mental incapacity and the alcoholism that this lady is accusing Megan Thee Stallion of having. So mental incapacity and alcoholism, and this is going to the defamation. Defendant also claims that her statements calling plaintiff legally, mentally incapacitated, we're going to use, and in need of a guardian are opinion or hyperbole, and thus not defamatory. She makes the same argument for her statements that plaintiff is a drunkie and from a family of alcoholics, claiming they too are exaggerations. True, vague, and fits. Empathets. I was like, what? True vague empathets are like calling someone a maniac or an idiot have been deemed non-defamatory opinion. But defendant statements go beyond casual name calling. She allegedly asserts or implied that plaintiff is legally incapacitated, requires a guardian, and suffers from alcoholism. And like I said, that can be true, proven true or false. Does she have a conservator? No. Then you are wrong, right? And you're going out and you're spreading this. She allegedly asserts, I think I already got that one. As plaintiff notes, legal incapacity is a verifiable fact. Citing a case finding that accusing a pilot of paranoia was not pure opinion, but rather a defamatory allegation of mental affliction. Likewise, Florida courts have long recognized that falsely labeling someone as an alcoholic can sustain a claim for defamation per se. They cite a case into falsely and maliciously charge one with being oftentimes drunk or with being an habitual drunkard is actionable per se in this jurisdiction. So you don't even have to prove that it damaged your reputation. You basically given that one for free. It damaged your reputation. It's costing you money. Okay. Per se, you skip a couple of the requirements. So let's go back into it. It's kind of like saying someone has an incurable STD. That is defamatory. Like we know that's going to ruin someone's reputation, right? Okay. So let's see. To be sure, the nature of online discourse can encourage an outspewing of thoughtless rhetoric, but the court cannot conclude as a matter of law that defendants' insults amount to nothing more than crude hyperbole. They cite a case declining to find that a statement, even one laced with insults, was incapable of being incapable of defamatory meaning. Given a reasonable person could interpret defendant's statement as accusations of perjury, mental incapacity, and alcoholism, the court finds that they are actionable defamation per se. And then as far as actual malice goes, they go, the First Amendment requires a public figure to prove that a defamatory statement was made with actual malice to recover damages. To plead actual malice, in turn, plaintiff must allege facts sufficient to give rise to reasonable inference that the false statement was made with knowledge that it was false or with a reckless disregard of whether or not it was false. The court's central inquiry is whether the defendant, instead of acting in good faith, actually entertained serious doubts as to the veracity of the published account or was highly aware of the account was probably false. Now, we saw this happen in the Cardi B case where Tasha K said it was false and she knew it was false, but she said it anyways because it got her more views, right? Same thing here. Megan Thee Stallion basically says that, let's go ahead and read it because I don't want to miss nothing here. So again, the parties agree, at least for the purpose of the motion, that plaintiff is a public figure. So she has to show that there was actual malice. The defendant says she has to prove it by clear and convincing evidence. That is not the standard, the court goes on to say. It's by preponderance of the evidence. The amended complaint makes a compelling case that defendant acted with reckless disregard for the truth. First, plaintiff asserts that readily available information contradicted defendant's statement at the time of publication, noting that defendant insisted plaintiff had never been shot despite medical evidence of bullet fragments showing otherwise. Second, plaintiff alleges that defendant knowingly spread these falsehoods by Peterson's direction, fully aware they were fabricated to harm plaintiff. Third, plaintiff contends that defendant's actions were driven by pure hatred. Finally, defendant seemingly profited from the defamation, gaining a larger social media following online and lucrative sponsorship opportunities. Defendant downplays these allegations, arguing that spite and a failure to investigate do not establish actual malice. No, it doesn't, but plaintiff's claims extend far beyond mere negligence. They paint a picture of an intentional campaign to destroy her reputation. That is more than enough to satisfy the pleading standard. They cite a case that says, as articulated by the Supreme Court in Iqbal and Tomley, notice pleading is the standard. So she went beyond just, okay, I don't know if it's true or false, but I'm going to say it. One, she keeps saying it over and over. And we just went through trial where it was proven in the medical records show, and it's been reported on and it's everywhere. The medical records show that she was shot. Her herself says that she was shot. I don't know if Megan Thee Stallion, people are going to call that out. She herself tweeted that Megan was shot because it hurt Tori's ego, whether she was being sarcastic or not. She said it, right? So those are the type of things that are going to come into play of whether she knew that it was true or false when she made the statements. And like I said, the court is not letting up off her neck. They're eating her up. I would for sure be talking to my attorney about how I can settle this thing. You have to settle it at this point. There's no way around it, okay? Y'all keep letting me know what y'all think. We're going to get to the comments in just a moment once we get to the rest of the document. So, promotion of the altered sexual spicy content is what we're going to call it. This is the next cause of action in Megan Thee Stallion's lawsuit. So under the statute, a plaintiff may bring a civil action against anyone who willfully and maliciously promotes an altered spicy content of her without consent. The statute defines promote broadly, covering actions like publishing, distributing, exhibiting, and presenting the altered content. Count 2 of the amended complaint alleges that defendant did just that. First, by liking a post on X.com containing a deepfake spicy content video of plaintiff, then by directing her followers to go to her likes page where the video remained accessible. The parties do not dispute that the video meets the statute definition of altered spicy content. They only disagree on whether defendant's conduct amounts to promotion. The court finds little precedent directly interpreting this section, thus it looks to the dictionary defamation for guidance. Here, the statute itself provides direction as it defines promote broadly to include actions such as exhibit and present. Exhibit means to present to view, and then to present means to bring before the public or to one's attention. Defendant allegedly did both. By liking the X.com post that featured the deepfake video, the video was exhibited on defendant X.com account likes page, which tracked and displayed liked posts for other users to see. Defendant also brought the video before the public when she allegedly directed viewers of her post to click on her likes page where the video had been archived. Defendant intended for this statement, go to my likes, to encourage her followers, other members of the pub and other members of the public to watch the deepfake video, which had been added to her likes page around the same time. Because plaintiff plausibly alleges defendant promoted the deepfake video under the section, dismissal is unwarranted. Yes, you told people to go somewhere where you knew they can find the video. If you want to see the pot of gold, follow the rainbow. That's essentially what she told him. If you want to see the pot of gold, follow the rainbow. Okay. Let's go on to the third count of intentional infliction of emotional distress. To state a valid IIED claim, a plaintiff must plausibly allege the following 4 elements. The defendant's conduct was intentional or reckless. The conduct was outrageous. The conduct caused emotional distress, and the emotional distress was severe. Defendant argues that her purported conduct was not sufficiently outrageous to support an IIED claim. That is going to be what the jury has to decide, okay? She insists that the allegations involve mere words and opinions rather than threat, assault, and other extreme behavior. The standard for outrageous conduct is particularly high in Florida. Conduct is offensive, harmful, and even criminal does not necessarily suffice. Outrageous conduct is usually something more than sexual discrimination or sexual harassment. As the Florida Supreme Court has explained, liability attaches only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Whether a claim meets the threshold depends on the sum of the allegations in the specific case at bar. As a threshold matter, defendant is mistaken in asserting that plaintiff has failed to allege a threat of physical violence. The amended complaint states that defendant threatened to slap plaintiff in retaliation for her testimony against Peterson. More significantly, the court declines to dismiss the IIED claim for two reasons. First, when viewed in context, defendant's alleged conduct possibly meets the extreme threshold for outrageousness, particularly given plaintiff's vulnerable mental state. A summary makes this evident. According to the amended complaint, Peterson shot at plaintiff's feet while shouting, "Dan," injuring her. At Peterson's trial, the defendant allegedly attended. Plaintiff testified about the shooting and described the lasting trauma she endured. After that, defendant allegedly aligned herself with Peterson, launching a campaign of harassment, publicly accusing plaintiff of perjury, calling her a habitual drunk, suggesting she was legally incompetent, and directing followers to a deepfake, spicy content video of her. Taken in isolation, any one of these allegations might not suffice, but taken together and against the backdrop of plaintiff alleged trauma, including suicidal, self-alive, thoughts about the shooting, the conduct possibly rises to the level of extreme and outrageous. Where would I want to go? Second, even if defendant conduct was not independently extreme, dismissal would be premature given the undeveloped factual record. And again, this is going to be something that the jury is going to have to decide. These are facts that have to come in play, and the jury has to decide what is relevant and what is not relevant. She keeps trying to say, nope. You got to wait for the jury on some stuff, ma'am. Okay. Second, even if defendant's conduct was not independently extreme, dismissal would be premature given the undeveloped factual record. The lack of any record evidence at this point concerning plaintiff's mental state and defendant's level of knowledge about it precludes such an early determination. Because plaintiff trauma and defendant's alleged exploitation of it are central to the IIED analysis, the court cannot conclude at this stage that the claims fail as a matter of law. Next, we go into the cyberstalking allegation that Megan Thee Stallion is making against this defendant. Next, defendant contends that plaintiff fails to state a claim for cyberstalking under the Florida statute, arguing that defendant's alleged conduct does not justify an injunction and that plaintiff has not complied with the statute procedural requirements. Defendant also urges the court to decline to exercise supplemental jurisdiction over the claim. Under the statute creates a civil cause of action for injunctive relief from stalking. Stalking occurs when a person willfully, maliciously, and repeatedly follows, harasses, cyberstalks another person. A separate section of the statute defines cyberstalking more precisely: to engage in a course of conduct to communicate or cause to be communicated words, images, or language by or through the use of electronic mail or electronic communications directed at or pertaining to a specific person. So she's posting on Twitter, she's posting on YouTube, she's posting on Instagram, talking crap about Megan Thee Stallion. So electronic means. It was causing substantial emotional distress to the person and serving no legitimate purpose. There's no legitimate purpose. Other cyberstalking claim, the plaintiff must allege that the defendant willfully, maliciously, and repeatedly engaged in a course of conduct that involved directly or indirectly communicating or causing to be communicated words or images using electronic communications directed at or pertaining to a specific person that caused substantial emotional distress to that person and served no legitimate purpose. Further, to obtain relief, the plaintiff must file a verified petition alleging the existence of cyberstalking and setting forth the specific facts and circumstances for which the relief is sought. And now this is the only thing that the court rules against Megan Thee Stallion for. One thing they rule against her for. This one thing. Plaintiff argues that she satisfied the standard of cyberstalking because she alleges that defendant willfully and maliciously engaged in a sustained course of online harassment, repeatedly spreading defamatory statements, using bot accounts to attack her credibility, and directing followers to a deepfake spicy content video. These communications made through electronic means were targeted at plaintiff and allegedly caused her substantial emotional distress, exacerbated trauma she already had suffered. Let's see. They cite the case saying, recognizing that cyberstalking is not limited to direct messages or email. Plaintiff also asserts that defendant's conduct served no legitimate purpose as it was designed solely to humiliate, discredit, and retaliate against her for testifying against Peterson. Defendant first insists that her statements had a legitimate purpose. Girl. The legitimate purpose that the First Amendment shields her from liability, precluding injunctive relief. The court disagrees. Plaintiff does not allege mere insults or hyperbole. Rather, She claims that defendant waged a campaign of intimidation and harassment against her. These allegations, taken as true, are sufficient to support plaintiff's assertion that defendant's conduct served no legitimate interest. And defamation is not protected by the First Amendment. Bullying people is not protected by the First Amendment, y'all. Defendant next argues that the plaintiff's petition for injunction against stalking lacks sufficient factual allegation and fails to meet the statute of procedural requirements. On this point, the court agrees. The petition merely states plaintiff is a victim of cyberstalking because respondent has committed cyberstalking, and then directs the reader to the amended complaint for further detail. So this is the only thing they rule against Megan Thee Stallion on. This is insufficient. Under the statute requires petitioner to the statute requires petitioner to specifically allege incidences of stalking, including when and where they occurred, and to mark applicable categories such as whether the respondent previously harassed the petitioner. The petition offers no such details. A conclusory assertion paired with a reference to an external pleading is not a substitute for a properly sworn statement. They cite a case that says the mere fact that an exhibit is attached to a verified complaint does not mean that the person verifying the pleading adopts under oath all statements contained in that exhibit. The petition falls short, lacking the necessary detail and failing to provide a sworn account of defendant's alleged cyberstalking and that's required by statute. Plaintiff all but concedes the point and indicates she would be willing to swear to the allegations she relied on to cure this defect. The court will permit plaintiff to cure the defect. So essentially, what happened is that Megan Thee Stallion did not do a sworn statement, so a statement under penalty of perjury saying this is what the defendant did to me, this is how it made me feel, these are the means that she did it. All of the things. She has not submitted one of those affidavits and basically said, I will submit one of those affidavits. Good lawyering. They realized their mistake and basically conceded that they would attach it. And the court is actually going to give her the opportunity to fix this so that the case can go forward. So although the court ruled against Megan Thee Stallion on not filing the affidavit, they are going to give her a chance to fix it. So that's good for her. Still, eating this girl up. The court is not a fan of the defendant. I repeat. Let's finish this up and then I'll jump into y'all comments in just a moment. Lastly, the court declines to relinquish jurisdiction over this claim because it has no discretion to do so. Plaintiff correctly asserts that diversity jurisdiction applies to the parties as the parties are completely diverse in the amount in controversy is $75,000. The court basically goes on to explain that it's not each and every claim has to be in excess of $75,000, but just the whole lawsuit altogether have to be in excess of $75,000. So even if the cyberstalking was only $10,000 worth of damages, maybe her defamation damages are like $100,000, so they would still qualify. It's not the cyberstalking has to be $10,000 and the defamation has to be $10,000. And what else did she sue her for? What else did she sue her for? I just went through all of that and I forgot what she can sued her for. Anyways, there was two other counts that I missed. So anyways, let's jump into the rest and ending of this about the attorney's fees in the case. Finally, defendant moves to strike plaintiff's request for attorney's fees asserted in count 1, 3, and 4, arguing that no contractual or statutory basis supports such an award. Even if defendant is correct, in federal court, there is no special pleading requirement for attorney's fees. A request for fees is just that, a request. Striking it now serves little purpose. Federal courts generally refrain from pruning pleadings based on speculative entitlement to fees, preferring to address the issue if and when the prevailing party actually moves for them. Should plaintiff ultimately seek attorney's fees, defendant remains free to challenge the request at that time. So basically, at the end of the case, if Megan Thee Stallion wins, that's when she would ask for the attorney's fees. Court's basically telling her, y'all are being premature, girl. She hasn't even asked for them all the way. She hasn't even incurred all her attorney's fees. So just pipe down, wait till she wins, and then you can talk about trying to get rid of them. And so the court went ahead and ordered that the motion to dismiss was granted in part and denied in part. Where it was denied is that Megan Thee Stallion has to submit an affidavit regarding the cyberstalking, and the court is going to allow, now I'm remembering them, the defamation to go forward, the intentional infliction of emotional distress to go forward, the cyberstalking to go forward once a Megan Thee Stallion cures the defect. And what was the third? What's the other one? And then the promotion of the spicy content. That's the one that I forgot about. So y'all let me know what y'all think about this, which I see people are commenting and letting me know. Thank you, Kimmy. I just now seen your comment in the back. People are already commenting, so we're going to jump in and see what the chat has to say about this lawsuit. Like I said, it's very interesting. The court ate this girl up, and I would really be talking to my attorney about how do I settle this, because this judge does not seem to be on this girl's side. Now, it's still going to rely on the jury to basically rule in favor of Megan Thee Stallion and whether they think that this girl was harassing her. But with all the statements that she has made and the videos that are going to come back out in the tweets that are going to come out, I think that although Megan Thee Stallion may not win on every single statement, okay, she's gonna win on something. She's gonna win on something. And if y'all remember, we covered the Meghan Markle defamation case, which was also in Florida, and that one did get dismissed on a motion to dismiss for failure to state a claim, because everything that her sister's Meghan Markle's sister was saying against her was opinion based. This girl basically tried to pull the same move against Megan Thee Stallion, and she lost. She lost. So I think that this girl should really be talking to her attorney about how to get her out of this mess, because it's a mess. It's a mess nonetheless, okay? And I don't think that she's gonna win. She might win on some causes of action, or some of the statements, but I don't think that she's gonna be able to win on everything. A lot of it is gonna be fact-based. And do you really want to pay the attorney's fees to go to trial to win on some and lose on some? That would be the question she would need to answer. Megan Thee Stallion got the money, and if she wins, she's gonna ask for attorney's fees. So hey, I think Milagro, whatever her name is, should just stop while she's ahead, pay this girl something, and move on, and issue a public apology, okay? Because y'all seen what happened to Tasha K. Y'all done seen what happened to Tasha K, okay? Let's go ahead and jump into the chats to see what the chat has to say about this lawsuit and y'all thoughts so far. Oh, and I forgot to mention that the court went ahead and not the court. The defendant went ahead and filed her answer, where she basically denied everything, which is normal for an answer. And they have approved the deposition of Tory Lanez. So that's going to be super interesting. Whenever that comes out, we will cover it if they file it with the court. We got Denny. Hello, welcome in. Say I'm not familiar with this one. It was actually started, I believe, in October was when the first complaint was filed, and then the first amended complaint was filed in December. So it's actually been open for quite a while. I didn't know about it until I started searching like YouTuber lawsuits, and it popped up, and I was like, "Ooh, this one sounds good." So here we are. Yours truly says she shows her face. She goes live all the time. I was just on her live the other day, and I didn't click on every single one. So please don't quote me on that. I did only click on one, and she did not show her face. She did not show her face in that one, and it could just be because I don't know why that was, but I didn't click on every single one. So I'm sorry. Kimmy Locker, member and moderator of the channel, consultant paralegal, thank you, says plaintiff's well-pleaded allegation sounds like nightmare fuel for the defendant. Yep. The court is saying they did good, and your position is wrong. Okay. Yours truly says a lot of what she said was posed as a question. Yes, that is true. But the questions and what the court is relying on is, if I say, for instance, in this case, has she been proven to be competent? Your assertion is that she's not competent. She's testifying on the stand as if she is competent, but has she overcome the fact that she has already been proven to be incompetent? So although there are questions, does not automatically make it an opinion. You're basically the underlying assumption, or you're basing the question on an underlying fact. That's the issue that she is running into here. Kimmy Locker says, oh, that's tricky. A lot of context and nuance can get lost when you take out the tone, body language, etc. of what someone says by putting it in text. Yes, that is true. That is true. So if some of it is on video, that is probably going to go against her, like how Tasha K's videos went against her. If they're just tweets, she might have a little bit more wiggle room. And again, it's going to be up to the jury to decide whether they think that she's being slimy, right? Is she being defamatory? Does she know that it's false? Also, don't keep talking about the same people. Like for me, I've been covering Diddy. I'm like, I need to get off Diddy because I might become in the spotlight. I know my channel is not big, but I could become in the spotlight and then they say I'm saying things wrong. But I'm very careful about what I say on my live streams. Okay. Yours truly says exactly the context. Kimmy Locker says, do you know if the judge watched the videos or formed their opinion solely based on the pleadings? According to the document, it says that they reviewed the submissions. I didn't see anything about watching the video. Let me go back up because that was a while ago. So the court based it on the record. So anything that's been said in the court or filed in pleadings, the party's written submissions, so these documents, and then applicable law. So no, it does not sound like they reviewed any of the videos. If that was attached to the complaint or anything of that nature, they could have, but it doesn't sound like it. I feel like they would have specifically mentioned that. Yours truly says, no, but I do know Meg and her team have been provided several opportunities to amend their claims. They can't get their story straight. It looks like they only amended it one time, and now she has responded to the first amended complaint. So I don't know about a bunch of amendments right now. As far as court goes, as far as their claims, they only amended it one time, which is pretty normal. You usually see people on their third amended complaint within months. So I don't think they amended it a lot, maybe in the media and whatever they're saying. But as far as court related, which is what we focus on this channel, is what's been filed with the court, they only amended it once so far. And that was to add claims versus changing what the allegations were. Yours truly thinks it's, I feel like it's a bullying tactic coming from Megan Thee Stallion team. Is that what you're referring to? Yours truly says it's all opinion other than things she knows are facts. But the question is, which one is going to be as facts? And so basically the court is saying leave it up to the jury. Because depending on the interpretation, depending on the evidence that they present at trial, the jury can decide, or the court will be able to determine, okay, this is law, or this is fact, or this is opinion, and then they submit it to the jury to decide what's going on there. They're going to need more evidence. The record is not clear here. Fiona Day says, Millie stalked Megan daily for 5 days. Who's Millie? Is it this girl? No, yeah, probably her. Yeah, that makes sense. And or for 5 years, I said 5 days, for 5 years. I was not following this when it came out. So y'all got to cue me in on some of the stuff. I only cover lawsuits. Fiona Day says the judge and Millie intentionally tried to destroy Megan's reputation. The judge in the Tory Lanez court case? I don't know if the judge can destroy her reputation. Yours truly says stalking is strong when she is a celebrity constantly in the news and Millie covers celebrity topics. That is true. But like I said, you can't keep covering the same people and saying all negative stuff. That puts a spotlight on you. I have to be careful on my own channel, and I cover lawsuits constantly. I only read pleadings, not articles, nothing of that nature. Okay? So when you are covering celebrities and it's all commentary and your opinion and you're saying things like, oh, this person lied, this person perjured themselves. Like I get on, we had the Amber Heard trial, right? And everybody was on there saying, I don't believe her. I don't believe her. She looks sketchy, all the things. But no one outright, none of the lawyers on YouTube came out and said she's perjuring herself, because you have to be careful what you say. And especially with being lawyers, the people that cover this and their lawyers, they're careful what they say, because people are really going to give you credit. If I got on here and said that somebody in a trial was lying, right? They're going to give me a lot more credibility than if some random Joe Schmo said it, right? Because I am boss attorney Bri. Attorney is in my name. People are going to presume I'm an attorney. People are going to say, well, she's an attorney. She knows what she's talking about. Like on the Diddy case that just got dismissed with Jay-Z. I said, I don't think the girl is going to be able to prove her case. But you'll see my comments that says, this is bogus. She's lying, this, that. I never came out and said that. I said, I don't think she'll be able to prove her case. because you have to be really, really careful about what you say online, especially if you're going to do commentary. Be ready to be sued. Be ready to be sued. Rachel Mills, Princess Ravella, love the name change, says, I feel so bad for Megan Thee Stallion. The abuse she endured is insane. And I just like, although I cover these things on YouTube and I talk about cases, there has not been a case that I've become so intertwined with that, you know, I'm going to follow it for 5 years and make my own personal judgments against the person. I cannot agree with them, and I will explain why I don't agree with them. But to get on there and to start saying that someone is not mentally competent, I think that's where she started running into trouble and calling her an alcoholic. The perjury stuff, plenty of people got on the internet and said they don't think that Megan Thee Stallion is telling the truth. Keywords think, right? And she's not suing them. She's suing the person that's going around calling her an alcoholic and mentally incompetent. And in addition to that, they're saying she's perjured herself. I think she made herself a target. And I agree. I feel bad for her. Being a celebrity does not just open you up for people to bully you. Rachel Mills says, Megan, the reporter, is trying to get the jailhouse calls in regards to Tory paying this person to speak ill of Megan. And she's saying she thinks that this girl was on Tory Lane's payroll, which is interesting. You would think he would pick a bigger channel, but these are the allegations. We'll get to see whether that comes out in discovery, right? Kimmy Locker says to Rachel Mills, it would be so dumb to discuss that on a recorded call. Now, we done seen what Diddy has discussed on his recorded calls, okay? We've seen what he's done on his recorded calls. We've seen what Donna Adelson done on her recorded calls. Or sorry, Charlie Adelson done talking to his mom on his recorded calls. These criminals are not that smart, okay? Would it be dumb for him to do that? Yes. Would he do it? Probably yes. Megan Thee Stallion motion to depose Tory Lanez was granted, so I'm super curious to see how that goes. Me too. I can't wait to see, and I hope they file it with the court. I hope they file it with the court so that we can read it and we can be nosy. That's what I hope for us. Rachel Mills says to Kimmy Locker, in her restraining order against them, she has some transcripts of some of the jailhouse calls about this. It's wild. Really? Where's the restraining order? I didn't even know she had a restraining order. Told y'all, only cover stuff. I need to see this restraining order. Kimmy Locker says to Rachel Mills, gracious me, the defendant better try to settle quick and in a hurry, and they've got that sort of evidence. That's what I'm saying. She has to settle. Whether she thinks she's right, whether she thinks it's opinion or not, the judge is already not on her side. The judge is already not on her side. And I personally have seen how that has gone in court. I have court tomorrow. And the judge can completely agree with me. She can think I'm annoying. I don't know. We're going to see how she's feeling that day. And while judges should not base their decisions on how they're feeling that day, it happens. It happens. And you got to roll with the punches. The law is very gray area. Like, we have these rules, and then one judge can interpret it one way, and another judge might interpret it a different way. This judge is not interpreting it the defendant's way. I would suggest she settles. Okay. Andrea Washington says, you know, jealousy has different faces. That is a thing. Was this someone Megan knew? I don't think so. I think it was just like somebody on YouTube. Rachel Mills says to Andrea Washington, this is a vlogger type who maybe Tory had a situation going with, or just saw that she was on his side. And so he kind of was like, okay, bolstered the conversation, according to Megan Thee Stallion. If that stuff comes out, which it sounds like some of it is already out, and at least the restraining order part of things, I would settle. I would settle because the judge is against you. The judge is already against you. They do not agree with your argument so far. And I honestly think her attorney made some pretty good arguments, but the judge does not think so. Okay. Fiona Day says Millie thinks it's a big joke until they make her pay. Did you not see what happened to Tasha K when that Cardi B and that Tasha K trial came out? I was like, there's no way that Cardi B wins because proving actual malice is really hard. And then Tasha K came out and said, yeah, I knew it was fake. What are you talking about? You got to pay now. $4 million later. $4 million later. You got to pay now. So I think they are starting to find defamation cases against celebrity a lot easier now. There's so much digital footprint that these people are putting out there. Like for her to say that Megan got on the stand and lied, what did she lie about? Are you talking about actually being shot? Because in one sentence, you're saying she hadn't been shot. In another sentence, you're admitting that she had been shot. It's crazy. It's crazy, right? Kimmy Lockett says, apparently, she's at least trying to settle because she filed a notice of service of proposal of settlement on 1/30 before this order, which isn't an admission of guilt, but is interesting to me. I did not see that. Thank you for pointing that out. I wonder how that's going. So maybe she knew it wasn't going to go her way. And like I said, I do think that the lawyers did a good job lawyering the arguments that she made, but the court's not on her side. And I'm happy that her attorney is sending out settlement offers to make it all go away. I'll take it down. Maybe I won't pay you no money, but I'll take it down and I'll issue a public apology. Does Megan Thee Stallion really need the money? Probably not. She'll probably just want it taken down. Rachel Mills says, how much time does this woman have on her hands to do this? She's a YouTuber. I don't know how often she posts. Like I said, I only clicked on one of her posts and she wasn't showing her face. I don't even have my phone. So I don't even know how many posts she makes on a weekly basis. But it's like me. I've been here 3 times this week and it's tiring, but I've been here. I don't know how much time she has on her hands. Haters gonna hate. Love the name. I used to always say that all the time. 2025 is turning out to be a wild year and it just started. I feel like we've been in 2025 for a long time though, because February has felt like forever. January went by like this. February has been going by fairly slowly, I have to say. Very slowly. But yes, it is turning out to be a wild year already. Y'all, that is all I had for the live stream today. Gabrielle George is saying, haven't caught a live stream for a while, but I like the Am I the A-hole videos you've been doing. Thank you very much. Those have been fun. They're definitely more interactive than our case ones. So I am going to keep doing it. I'm thinking about doing it more on members only and then posting the stories individually. I'm thinking about doing that. Probably not for a while though. So, but thank you for joining live. Happy to have you here and back. And hopefully you can catch one of the live stream Am I the A-holes sooner rather than later. Thank you. Kimmy, what is this that you didn't send me? Oh my gosh. Uh-oh, where did my screen go? Oh, here we are. Molly, you in danger, girl? That's what you said. Kimmy saying, I feel like 4-second movie clip is funny in a good way. Let me see. I'm trying to get it to go to the right place that's for me to be able to share it. Okay. Kimmy got a video she wants to share with us for the nonsense that this girl is putting us through at this point. So we're going to stop sharing our screen. We're going to share it again. Oh, nope. We're not. Here we go. Okay. Here we go. This is what Kimmy got for us. Uh-oh.
Molly, you in danger, girl.
She gotta quit. She has to. She in danger. She is for sure in danger. She has got to settle this case. Kimmy saying, glad to make it to Gabrielle. Yes, of course. Thank you everyone that joined me live. As I said on the live stream last night, I will not be streaming next week unless I get bored, okay, on the ship. I am going on a cruise next week, so I am not going to have internet connection. So maybe as I'm getting ready or something for something, maybe I'll stream, but it probably won't be about a case. Maybe it'll just be about what I'm doing on the cruise that I'm going to be on. But you guys can expect that I will not be streaming, and if I do, it'll probably be a vertical stream just to chit chat, okay? Kimmy Locker is saying, am I the a-hole cruise edition? Maybe we can do that. Maybe we can do that. I will look into that. I did pay for premium Wi-Fi. So if it's premiuming the way I need it to be premium, then maybe we will do Am I the A-hole cruise edition while I am traveling. Other than that, you can expect that I will not be streaming. I told you guys last week, I think, that I'm in the middle of transitioning careers, transitioning jobs. So that may also change our posting schedule on the channel. I'm still going to try the 3 times a week, but I am going to start clipping some of the live streams that we have, and I'm trying to figure out the logistics on that. I know y'all don't care about the logistics, but I'm telling y'all what you might expect to see from the channel moving forward. So anyways, thank everyone for joining me. I think this girl has got to settle. She has no choice but to settle at this point. And hopefully Megan Thee Stallion will take it easy on her, because this girl probably does not have the money to go through civil litigation. And honestly, Megan Thee Stallion probably doesn't even need the money. She just needs you to stop saying crazy stuff about her. And I would honestly suggest, based on the one video that I clicked on and the several videos that are on her page, just all the gossip, she might want to change her content style a little bit so that she does not get hit with any more lawsuits like this. And that's why I'm very, very careful to cover lawsuits and the pleadings and not just articles and the he said and the she said. We want to cover things with litigation privilege. We're reporting on litigation where they have the privilege. So I'm going to extend that privilege to me. Maybe it doesn't extend to me, but I'm going to make sure that I am only covering things that are coming directly from the people that are suing. And maybe she needs to change her little approach on her commentary channel. But anyways, that is all I have for the live stream today. Thank you everyone for joining. I hope everyone has a good weekend. Maybe I'll see y'all on the cruise next week. Maybe I won't, but I will see y'all all on the next live stream. Bye.